Kia ora koutou, ko Sylvie tōku ingoa. My name's Sylvie. I'm MyHR's Chief Evangelist, for those of you who have seen me or haven't seen me around before. You may have been expecting my colleague Jocelyn today. As we did a few weeks ago, something came up with our schedules today, and so I'm swapping in for her as she swapped out for me a couple of weeks back. So I'll be taking us through today's session. I hope you're not too disappointed, but Jocelyn will be back with webinars in the next couple of weeks. So today's topic, of course, is probation and trial periods. The content we'll be covering off today is very much looking at trial and probation periods from an employer and a manager's perspective. So if you are an employee yourself, as many of us are, but if you have questions about trial periods from an employee's perspective, you may not find this is quite the right session for you. If you do have any questions, you are welcome to answer them, and I'll do my best to cover off at the end. But just a reminder that today's session is around probation and trial periods from the employer's perspective. So we've got around 40 people joining us today, which is wonderful. Thank you so much for choosing to spend some of your Wednesday afternoon with us. What I will do is share my screen to get us into the presentation, and then we will get started with a bit of housekeeping. See if I can get the slideshow going. Perfect. Awesome. So in terms of today's topics, we will cover off and start with a bit of housekeeping. We'll jump into then the purpose of trial and probation periods, just to talk about what they are, why they exist, and how they're meant to be used. We'll talk a little bit about good faith, because particularly with probation periods, which aren't governed by such specific laws as trial periods, it's a concept I'll refer to a few times. We will then, not in order, sorry, talk about probation periods next, where they've come from, how they're used, and what to be mindful about them. We'll then jump to trial periods, and of course, we'll have time for questions at the end. So we'll start off with a bit of housekeeping. The session today will be recorded. So if you have something come up and need to duck away, or if you have issues with the tech and the audio that isn't working for you at any point, you will be able to access it after the session, so you won't miss out. What this does mean, of course, is that any questions you ask or discussion that we have will be available in a public forum later. So keep your questions anonymous. If you ask them with identifying kind of information that I think might be best kept off screen, then I'll anonymize them when we get to them. But these sessions, I say this every time, but they really do come alive when there's a lot of questions and a lot of audience participation. So if there's anything that I say as we go through that you would like to question or understand more, if there's anything I say that you want to challenge and push back on, I love it when that happens. It doesn't happen as much as I would like, but when it does come through, it's quite fun. Or if there's anything that's happened in your business or in your team or your experience that you'd like to dive into, I really welcome you to put those questions forward, and we'll be answering them at the end. So even if you ask questions as we go along, I will pick them up at the end of the session. So I haven't forgotten or not seen them. We'll just address them together towards the end of the session today. I've just had one question come through. I'm just going to check. Yes, so Deborah's asked, is the webinar being recorded for us to view later? Yeah, you're totally right. It'll be available after the session. Cool. So let's get into it then. So why do we have trial and probation periods? What are they? What's the purpose? What are they meant to be doing? So they're here to give employers and employees a chance to assess fit and suitability for a job that you've got. So we know that recruitment is sometimes a dark art, not a science. It's certainly not foolproof. And there are times when, as business owners or managers, we've hired someone who we thought was going to be awesome, but it turns out that maybe it's not quite the right fit for them. Maybe they're a dickhead, we don't want them in our team, or maybe there's just been a miscommunication, and for whatever reason, it's not going to be a successful relationship. Likewise, for employees, particularly in a tight labour market like we are in now, they can be sold the dream, they can be told it's one thing and it turns out to be something different. So the trial and probation period timeframe is intended to be a mechanism for us to assess whether this is going to work long term, and to mostly give employers an easier route to move someone on if it's not going to work. So there's totally a power differential here. I don't want for it to sound like I'm not acknowledging that, but certainly the purpose is to assess fit and suitability for a role. And we'll come back to that language later. The phrasing of it is quite important. So this thing called good faith, you'll hear HR people and lawyers talk about good faith a lot. And I wanted to spend a moment on it because it becomes relevant when we talk about how to manage or how to respond to challenges that come up during a trial or a probation period. So in the Employment Relations Act of 2000, which replaced the Employment Contracts Acts of 1990 or 1991, Section 4 says that employees and employers have a legal obligation to deal with each other in good faith. It goes above and beyond just kind of trusting each other and being confident that we're going to not be dicks about it. And it goes to the level of specificity as to say, we must not do anything, either directly or indirectly, to mislead or deceive each other, or that is likely to mislead or deceive. So we have to be honest and proactive about that. We can't kind of mislead by omission or deceive by omission. And certainly we must be active and constructive and responsive and communicative. So this is a really black and white legal obligation that we have, which governs the way that we deal with our employees and our employees deal with us. So obviously these are broad principles. They don't specify how to behave or respond in every single scenario. The law would be, you know, 1 billion pages long. But in terms of thinking about how we communicate with our team and how we particularly give employees feedback and manage them during their onboarding period when they're in these probation or trial periods, I'll come back to this and explain why it's important and talk about kind of where this principle comes into play. But important to highlight at the top of our discussion. So I figured we would start with probation periods because they've actually been around a lot longer than trial periods have. They're becoming more common now that the law has changed to restrict or to cap kind of how large a company is before they can use trial periods. But I wanted to be clear that they have been around for a long time. So the earliest reference that I've been able to find, which refers to kind of the principles that govern probation periods, is a 1994 case from the Court of Appeal, so quite a while. They're not defined in legislation. You won't find in the Employment Relations Act or any of its amendments any references to probation periods. They don't exist. But it's something that kind of businesses and employers have sort of been using. And when someone first went, hey, I don't think it's fair that I should have to be in a probation period when I start a job, the court said that's actually kind of okay. Like you can agree to a period of probation or to trial someone out, and that's not a breach of your good faith obligations. It makes sense given that particularly the employment relationship between employers and employees, it's a relationship, right? It's not a contract. It makes sense that there would be this period of time to assess fit and suitability. So probation periods can be used for new employees. You can put them in place for existing employees in a couple of specific circumstances, and you can use them for returning employees. They're a pretty broad mechanism to assess fit and suitability. So for a new employee, reasonably obvious why you'd use it. You haven't worked with them before. You don't know if they're going to turn out to be, again, not dickheads. For existing employees, you might use them where if you were shifting someone from a role where they were definitely going to succeed, if they were taking on a new job that was going to be quite a large promotion for them, you might put a probation period in place which either had them exiting from the business, so basically losing their job if they weren't successful, or more commonly and kind of in better faith, might have them reverting back to their previous role if this new job, if it wasn't going to work out for whatever reason. So you can use them for existing employees, and you can also use them for returning employees. So if you've had someone work with you before, they've left and gone to a new job, or they've left to go do some travel, or they left to, have some personal projects and they now want to come back to work from you, you can have a probation period in there if you'd like to. Hopefully you wouldn't hire anyone back who you didn't like and didn't trust to do a good job. But if for whatever reason it's a bit marginal, you might want to put a probation period in there just to manage the situation in case you need to. Probation periods too can be any length of time. So typically it's 3 months. I don't often see probation periods shorter than 3. Sometimes you might see 2 months in a role that is quite transactional and you can pretty quickly pick up if someone's going to be good or not. I have seen them of up to 6 months in length for quite senior roles, but that's less common. Certainly 3 months is kind of that typical window. Anything from 2 to 4, I think, could be fine. Anything longer than 4, you'd probably have to have a pretty good reason for wanting it to be that length of time. But as long as it's fair and reasonable, and as long as the employee agrees to it, you can have them be any length of time. Now, a piece of guidance that came out of that 1994 case that I mentioned, which was between Nelson Air Limited and the Airline Pilots of New Zealand Association. I might have got those words around the wrong way, but between an airline and the Pilots Association. One of the principles that came out of that case was that employees, quote, should usually work the whole length of the probation period. The idea being that you have said to someone, hey, Sylvie, you're going to come start a role with us. We want to see that you're going to be fit for the role and that it's going to be a good fit. We're going to put you in a probation period of 3 months to check this out. But in fairness, we're going to give you the whole 3 months to put your best foot forward and to show us how awesome you're going to be. This means that if you have a probation period and you want to cut it early, even if this person is obviously, well, no, I shouldn't say that. If you want to call it earlier in a probation period, you would need to have pretty exceptional circumstances that clearly show this person is just a round peg in a 4D hole, that they are clearly not going to be a good fit for the job. Most of the time, our advice is going to be give someone the whole length of the probation period to show you what they can do, because there is specific legal precedence for expecting that employees kind of get a fair go, that they get the whole length of the probation period to show whether they're suitable. Critical here too is that employees must sign up for the job understanding that there is a probation period involved. So the law here is less rigid or particular than with trial periods, but it needs to be obvious to them that a probation period was involved. So if you offered a situation that wouldn't meet this threshold is if you met someone you liked and interviewed them and offered them a job, that's awesome. If you then didn't say to them at any point, hey, just a heads up, there'll be a probation period in there, make sure you have a read through of your employment agreement to check you're comfortable with it. Or say you gave them the employment agreement the day before they were meant to start and told them, hey, you've got 30 minutes, you better get it back to me or I'm going to yank this offer from you. Any circumstances where it wasn't clear to them that there was a probation period involved, or where they didn't really have enough time to practically understand what that means that you may not be able to terminate them under the probation period later. So whatever way you communicate that, however much time you give them, you have to be fair and reasonable. And in good faith, if someone signs up for a job with you, they should understand and be aware of what having a probation period in place means. They also must be given support and training. So sitting someone in a corner and going, hey, here's a laptop, here's your cell phone, make a bunch of sales, I'll check in with you in 3 months, see you later, bye. Under no circumstances would be considered kind of fair behavior by the employer or the manager. And if you didn't give someone fair support and training, then again, it's unlikely you'll be able to terminate because you haven't held up kind of your end of the bargain. So it's pretty accepted now that employers who have new employees must give them support and training, right? So this doesn't have to be someone sitting with them every single minute of their working shift to show them what's happening for 3 months. That would be unreasonable. But on the other end of the scale, also just leaving them alone and hoping they get it and then firing them if they don't isn't fair. That's kind of not reasonable behavior. So whatever the support and training that you have is, make sure it actually is enough for someone, for your average kind of person to get a good understanding of the role and to be successful. If you have employees who need a bit of extra support, so for example, someone who's maybe been out of the workforce a long time and needs a bit more coaching to get their feet under the desk, anyone who's got a learning disability or a developmental disability, which means they'll need a bit more coaching, or someone who's transitioning industries, is kind of taking a bit of a different career path. Those people quite fairly are going to need a bit more support and guidance than other situations. So make sure that you are within reason kind of accommodating for people's individual circumstances and making sure they have the support and training that they need. Now, this is what has become much clearer in the case law over the last, how long has it been? Case law over the last 5 years now, since trial periods kind of had the cap put on them. So if during a probation period you're saying to someone, hey, Sylvie, I know that we hired you for this receptionist role, and if you're meeting with me every week and giving me feedback, that's awesome. And if some of that feedback is, hey, Sylvie, we're getting a bit concerned with the amount of calls that we receive where someone's left a voicemail and are not getting calls back, we're getting complaints, kind of what's happening. If you're giving me that feedback, that's great. You must also, at a point where it's reasonable for me to course correct and improve my performance, say to me something to the effect of, if this performance or this behavior doesn't improve, we may consider terminating under the probation period clause in your employment agreement. So again, if there is behavior or performance that is likely to prompt you to axe someone under the probation period, at a point where they could reasonably improve on that behavior or reasonably course correct, you need to say to them, if this behavior or performance doesn't improve, we may consider terminating under the probation period clause in your agreement. Now, so the courts have said it's not actually enough to be giving people feedback or guidance that their performance or behavior is not good enough. You have to make it clear what the consequences of not improving will be. Otherwise, they may not clock how serious it is and may not have all the information needed to really give it a good go to improve before you fire them. So there are a few cases in the last, I'm going to say 3 to 4 years since that trial period limits come into play, where business owners have been caught out because they've been saying to their newly hired accountant or their barista or their HR manager, whoever it is, and saying, hey, this is not going that well. Like, you keep missing these deadlines. These coffees are continuously burnt. These figures and spreadsheets you keep preparing continuously have errors in them. You need to improve this. And they're doing the right thing. Giving that feedback is totally appropriate. But what they missed was saying, this is now concerning enough that if we don't see a significant improvement, or if you don't get to this level of accuracy or this level of no complaints or whatever your measure is, we may consider letting you go under the probation period clause. They didn't say that. And so when they came to fire the employee or employees, they were somewhat understandably surprised and taken aback and were disadvantaged by not being aware of the consequences of not lifting their performance. That may seem a bit harsh to those of us who are like, duh, like, if you ultimately don't get any better at your job, of course you should expect to potentially lose it. But the courts are really clear that that good faith obligation to be proactive and communicative it means that as employers and managers, we have to be as explicit as to say, your job may be on the line and we may consider terminating if it doesn't improve. I really want to hammer that home. What's difficult is that that's a really friggin' demotivating thing to hear, right? Like, if I was in a new job and 6 weeks in, my boss was like, hey, kind of teething issues, and like, I'm a bit concerned about this. If you don't improve, I might fire you. Like, that's a really awful conversation to have to receive and be a part of. But if you don't have it, or if you don't figure out a way to have it, you may not be able to terminate that person if you do want to consider doing that at the end of the probation period. So it's really important to make sure that you are supported and that you plan to have this discussion with them at a point where it's reasonable for them to course correct. They also must be given opportunity to improve. So if you, the two scenarios I see most often is if the probation period's for 3 months, so call it 12 weeks, at month 10, a manager has now gotten so frustrated or is so close to the probation period ending that they will say, hey, Sylvie, I know that I hired you as my barista. I know that we've been having feedback conversations every couple of weeks, and I've been clear that your performance needs to improve. We're now at a point where if I don't see an improvement, I may consider ending your employment under the probation period clause. I've now only got 2 weeks, practically a bit less than that, to suddenly figure out what I'm doing wrong and learn and improve what I'm doing at work. That realistically isn't a fair amount of time for me to improve. So they must be given enough time to reasonably course correct, which is why we don't often see probation periods of less than 3 months, because it's hard to fit all this in. But you can't tell them 2 weeks beforehand that their job might be on the line. That's not going to stand up. The other situation I see is where someone shows up, usually in the first month or so, is given some tasks and responsibilities, mucks them up and is a bit shit at them. So the employer goes, okay, well, I'm not going to have you customer facing anymore because you keep annoying people. I'm just going to pull you into the back office and keep you here, and then I'll kind of figure it out. And at the end of the probation period, they'll try and say, well, they were so bad at these duties, I had to pull them onto kind of half of what their job is. And I don't see a way for them to get better, so I'm going to end them under the probation period because, you know, it was so bad and I can't see a way for them to get better. The fact that you pulled them off those tasks and didn't give them the support and the training to improve means that you are at fault, right? Acknowledging that they pissed off your customers and you had to deal with that. You can't yank them off the thing that you actually need them to be doing and later go, well, you're not good enough at this, so I have to let you go. There has to be an attempt to support them to improve within a reasonable time period. Otherwise, if you do run a probation period termination, you run the risk of a successful personal grievance claim. Which very conveniently leads me on to this personal grievance piece. So probation periods have no protection from personal grievance claims. If you sexually harass your employee, or if they experience bullying from a colleague, if you disadvantage them, if you choose to end their employment, they can bring a personal grievance against your business for any of those grounds. There is no special protection. We know from, I think the last figures I saw were 2020 or 2021, that if a personal grievance claim goes to the Employment Relations Authority, so that first decision-making body in the legal hierarchy, the average cost to win a claim where the authority member finds you've done no wrong is around $28,000, $29,000. The cost to lose, if you are in the wrong and you did make a mistake, is around 75, kind of 78 grand. So so all of your time, all of your advocate or your lawyer's time, attending mediation, attending hearings, and so on. So you really do not want to be facing PG claims where you can avoid them. Grumpy employees sometimes have a crack, and we kind of can't do anything about that. But where possible, you do want to make sure that you're following a really prescribed process and doing it for the right reasons, so that if there are PG claims, it's not something that you're going to lose because you were in the wrong. All right. Taking a breath before we jump onto trial periods. So, trial periods were introduced in 2009 via legislation. So unlike probation periods, which kind of just emerged the thing that people were doing, trial periods were a specific legal mechanism that was introduced by the Parliament at the time and went through select committee and all that kind of stuff. And the purpose of introducing trial periods was to provide employers more confidence when hiring new employees. So it was kind of a roundabout way of trying to get better outcomes for employees, right? If you've got a criminal record, if you're, again, returning to the workforce after a period of time away, if you have had a bit of a dodgy history or whatever with short periods of time in between jobs, if you've been incarcerated, whatever the deal is, employers somewhat understandably are going to be a bit wary of hiring you, perhaps. So having a trial period in place, which for the reasons as we'll see, makes it easier to get rid of people in their first 90 days, was intended to give employers a bit more confidence so that they could give these employees who maybe wouldn't have been given a chance a bit more of a go and a bit more likelihood in securing employment. So originally, any organisation could use them. So from 2009 onwards, which is certainly more than the history of my entire HR career, organisations have been able to use trial periods, which means probation periods kind of vanished. Like we didn't really have them from 2009 up until the point where this cap was introduced. So what happened is that a few years back, the Labor government said, we actually don't think it's fair for organisations like Westpac or for organisations like Frontiera or for the Ministry of Social Development, these huge organisations with lots and lots of resources. We don't think it's fair that they have access to this legal mechanism, which we'll see in a couple of points, reduces employees' rights to bring claims in respect of their dismissal. Employees are giving up a very fundamental protected right to bring a PG in relation to some aspects of their employment. In exchange for that giving up of rights, we think it's fair that large employers with plenty of resources shouldn't have access to that. They have the resources to train and support and coach people. They have the resources to manage their terminations kind of fairly and with process. So we're going to cap the size of the organisation who can access the trial period to organisations with 19 or fewer employees. So we totally recognise that for very small businesses, you don't have a lot of resource or expertise always in ER. We recognise, that it might be reasonable for you to want access to these mechanisms. So we're going to keep that, but anyone who's got 20 employees and over, you guys don't have access to trial periods anymore. You have to go back to using probation periods. So I don't think that's that unreasonable. I think the logic behind the fact that employees are giving up some of their kind of long-standing employment rights is quite a big thing with the trial periods. So capping it, I think, was a logical, if not widely popular move from the government at the time. So in terms of counting your 19 employees, it's however many employees you had on the day the employee signs the employment agreement. So even if they start on, what are we next week? I'm having to live in my calendar these days. So next week is going to be the Tuesday the 11th, right? So the day after Easter. If we had an employee sign their employment agreement today on Wednesday the 5th, and we're on the cusp of that 19, 20, 21 employees, it's how many employees I have today. So if today I have 19 employees and the employee who signs the employment agreement is the 20th employee, they cannot have a trial period. By their signing, they tip us over that 19 threshold. They're the 20th employee, they can't have a trial period. Even if on the day that they start, I'm going to go back down to 19 again because the person they're replacing leaves this week. It's not about start date, it's about the day that they sign their employment agreement. And that 19 headcount includes your casual employees, it includes your fixed termers, basically anyone who's an employee who's on your payroll. So the key difference between trial periods and probation periods is that an employee who is dismissed under a 90-day trial period cannot bring a PG against you in relation to unjustified dismissal. So I don't want to say you have free rein to fire them because that kind of soundbite gets run with, you know. But certainly if you have a trial period, it's valid and you use it, the employee has limited legal recourse, which is why the government is so careful about giving access to this mechanism. But what they can do is bring a personal grievance for other reasons. So if they were, again, bullied during their time with you, if they were discriminated against, if they were harassed in any way, if they were disadvantaged in other ways, they can still bring a PG for those claims, but just not in respect of them being dismissed under the trial period. Unlike probation periods, this can only be used for new employees. So if you have an employee who's returning, so who worked for you a couple of years back, took some time off for some travel, has come back now and is back with you, you cannot use a trial period for them because they used to work for you. They're no longer a new or a brand new employee. If you've had a contractor before who's now becoming an employee, that's okay. They've never been employed by you, even though they've worked for you before. So a contractor switching to an employee, you can have a trial period. Employees who are moving from one position to another, no trial period. They currently work for you, so they're not new. So it's a really limited population of people who you can use a trial period for. There's also a cap on time limit. So a trial period can be less than, but can be up to 90 days. However long it is must be specified in the employment agreement. So a clause that says Sylvie will be subject to a trial period of up to 90 days is invalid. However else amazingly you manage the process, if you try and fire me under that trial period, I can raise a claim against you and I'll win. So don't do that. You can say a trial period will be 90 days applied from the first day of starting work. That's fine. You can say it's 60 days. That's cool. But 90 days is the absolute max. Unlike probation periods, an employer can more quickly say, I can clearly see that Sylvie's not suitable. I'm going to move her on. You still have to act fairly and reasonably. So you probably couldn't fire me at the end of week one. Like, how can you possibly reasonably assess that I'm going to be fit for the job in a week? But unlike the probation period, there's no expectation that by default I would get all of those 90 days. If after 4 or 5 weeks, it's clear I'm not up for the job. If otherwise you've been fair and reasonable and given me training, given me support, given me feedback and a chance to improve, you can move me on there without any legal risk. Now, more specifically than probation periods and how they're governed, an employee must have fair and reasonable time to review their employment agreement, or the trial period is invalid. So the guidance we give our clients is to say a minimum of 2 working days, right? So if Sylvie starts work on a Monday, she needs to have her employment agreement by close of business Wednesday, so that she has all of Thursday and all of Friday to review and seek advice if she wants to. Now, that 2-day minimum it's a minimum, it's a floor, not a target. So if you're hiring someone who is a single parent or who has other commitments, maybe someone who's in the middle of traveling and moving countries and coming to New Zealand to start work with you, what's fair and reasonable for that person will be different than someone who's doesn't have other commitments and can seek time pretty quickly. So where you can, try and aim for about a week. If you're not sure, seek legal advice. You'll get some guidance on fair and reasonable time, but a minimum of 2 working days. Otherwise, you run the risk of the employee not having had fair and reasonable time to review their agreement and seek advice if they wanted to. Unlike probation periods, again, the employment agreement must be signed before the employee starts. So if you give them the employment agreement a week in advance, awesome, you're doing well. If they then show up for their first day of work and go, oh shit, I'm totally sorry, I've forgotten to sign my employment agreement, I'll do that at lunchtime and give you a copy, their trial period is invalid. You've lost that protection. The legal argument is that, or the legal reasoning, which has been upheld many, many times by the courts, this is not a black and white question, is that if an employee has started work with you and then signs their employment agreement, they're no longer a new employee. Right? They're an employee who has started work even for only a few hours, and then they sign the employment agreement. They're not new anymore. You've lost that protection. So IA must be signed before they've started. Like probation periods, the employee must be given support and training. Again, doesn't have to be someone sitting with them and holding their hand for 90 days, but it has to be fair and reasonable generally, and fair and reasonable for that person's circumstances to pick up and learn the tools of the job. Or learn the ropes, I guess. Like probation periods, they must be told that your job will be on the line. We may consider terminating if your performance doesn't improve. And again, that has to be with enough run time or runway, I guess, for them to genuinely lift their performance. So that must be made really clear to them. And again, they must be given that chance to improve. So actually given a chance to show that they've learned now how to talk to customers and they won't start flipping people off, but also with enough time that they could reasonably meet whatever the standards that are expected of them in their first few days. So that was a lot of information from me. We've kept it to just over half an hour, which is excellent time work. Well, excellent timing. Well done, us. I'm really keen to leave a bunch of room for questions because there are a lot of nuances and weird things that come up with trial periods and probation periods. So what I'll do is I will stop sharing the screen so you get more of my beautiful face answering these questions, and I'll jump in and start running through them. We've had our original attendance grow to 70, so thank you everyone for attending today. I appreciate your attention. And if you do have any questions or anything that you want to understand in more detail, pop them in the chat and I'll start going through them now. So Torben says, hey Torben, if you want to let a person go prior to the probation period being completed, can you send them home but pay for the 3-month period? I realize the person has to be pretty useless or doesn't fit the culture. Good question. If you are firing someone under either a probation or trial period, you have to give them notice, right? You can't just fire them and say, too bad, so sad, see you later. Whether it's a 1-week notice period or a 4-week notice period, under whatever circumstances, you must pay them for notice. If you, after a month of a 3-month probation period, went, man, Sylvie's a real knob, like we just don't want her around, she's really difficult. And if I had, let's say, a 4-week notice period, so I've done a month of the trial, I've got a 4-week notice period, and then there's kind of a month of probation. What you could do is offer to pay that extra month of pay under section 123 in a record of settlement, which means that you would say, hey, Sylvie, you're a bit rubbish. We don't really think you're going to improve. We're offering to pay your notice period to you as we're required to anyway. But also if you go quietly and don't make a fuss, we'll pay you this extra 4 weeks of pay, but we'll get a record of settlement signed so that you can't bring any legal proceedings against us. This is full and final and it's totally settled. So the short answer, Torben, is you could. It would take a little bit of legal wrangling, and it would require you as a business to kind of have the appetite to pay someone you don't like 4 weeks notice and whatever the remainder of their probation period is. If you think about doing that, get some legal advice. What I've just described is not as straightforward as kind of me talking through it quickly. But the short answer is I think you could. You just have to frame it a bit thoughtfully. So thanks for your question. Anonymous says, what if you hire someone whose performance has degraded over time, say 2 years on? Is there a situation where one can impose a probation period if we don't have a probation period in their contract? Great question. So I wouldn't recommend that approach. Probation periods are really clearly in law, well, in case law, defined as being for the purpose of assessing skill and fit for a role at the beginning of the employment relationship. I don't think, even if you got the employee to agree to it, I don't think the courts would support using a probation period later because they're not new. Like, you've hired them, you've got other tools for managing that. So it's sadly quite common for later in the employment relationship for there to be performance concerns. And the tools that you have to manage that are things like performance improvement plans, things like disciplinaries, things like just kind of conversations and giving them guidance. So you absolutely have a pathway to firing someone if their performance sucks later in the employment relationship. A probation period is not the right tool to do that. If you're keen to discuss that further, Anonymous, you're welcome to get in touch. There's heaps of resources on the website. You can fire someone who's shit at their job later, but a probation period is the wrong tool to do it with. Cool. Megan says, hi, Megan. Does that have to be in writing? And by does that have to be in writing, you mean telling them we may consider terminating under the probation period? The short answer is legally it doesn't, but I would always recommend, even if just in some notes or a short email after a discussion, kind of capturing what was said. And the reason I say that is when people hear their jobs are on the line, they go into a bit of shock, right? Like it's a frightening thing to hear, and our brains immediately go into kind of fight or flight mode. The like logical listening part of our brain switches off at that point. So to be fair to the person you're dealing with, I would always suggest, if you've had a heavy discussion like that, following up with a short email, even just to say, hey, so-and-so, I appreciate that was a tough discussion. I just wanted to recap what we covered off so we've got a record of it. So one, just to make sure they understand. Two is later, if they raise a claim against you and say, I was never told my job was on the line, my employer's missed a key part of the process here, you can go, no, like, here are the email trails. Even if it's not an email, here are the notes that I took all through their onboarding process and program, which was documenting feedback. And here's the note on the 5th of June, where I said, met with Sylvie today, told her if performance didn't improve, probation period might be invoked. Like, on the balance of probabilities, I did tell them this. So legally, it doesn't have to be, but for the sake of the person who's understanding and for the sake of just avoiding that being a claim that might be raised later, I would always recommend capturing it in writing somewhere. Anonymous asks, again, can we have the feedback conversations where we tell them their job is at risk verbally? Do they also need documentation? I would always recommend documentation for the reasons I've gone into. It's not legally required, but it is practical and just gives you a bit of a fallback later if things go south. Jenny, hey Jenny, asks, is the trial period count of 19 or less including part-timers, or is it on a pro rata basis? For example, 18 full-timers and 2 half-time would be 19 or 20. That's an excellent question. It's based on headcount, not FTE. So if you had 19 employees who all worked 20 hours a week, you have 19 employees. You have 9.5 FTE, so 19.5 full-time equivalents, but you have 19 people who are employed by your business, and that's the count that matters, not the proportion of people who are full-time, the actual number of humans that you employ. Deborah, hey Deborah, says, if we have an employee who's been working for us through a recruitment agency for, say, 6 months, and you want to offer them a fixed term or a permanent IEA, and you have more than 20 employees, can we include a probationary period? Yep, that's totally fine. So probation periods can be used for new employees, for returning employees, pretty much anyone who agrees to the clause, as long as it's reasonable and, again, is at the beginning of that employment relationship. So whether they have or haven't worked for you through an agency, even if you had fewer than 19 employees, you could put a probation period in there if you wanted to. So the answer is yes to your question. You could include a probation period. Peter, hey Peter, says, after a trial or probation period, if a person is not suitable, is it necessary to give reasons why the person's being laid off? In the case of a probation period, yes, you must explicitly tell them why they aren't suitable for the role, and that includes at the time the firing is being proposed, as well as the time at which kind of you're confirming that they aren't suitable. So you have to be under that good faith requirement, proactive and communicative, which includes giving them a reason as to why they're not being kept on. Trial periods are a bit more nuanced. So to be 100% legally safe, we always tell our clients to be clear with someone about what the concerns are, what might happen if they don't improve, and then at the time you're considering letting them go, to say, hey, we're proposing terminating under your trial period for XYZ reasons. You get some time to think about it. Tell us what you think. Now, the legislation says that you don't have to offer a reason for why they're being terminated at the time you're firing them under a trial period. But case law says that if an employee asks why they're being fired, you need to tell them. And the reason for that is the courts have said if an employee is losing their job, like losing your job is a big deal, okay? Like that's serious and scary and a big situation to go through. So where an employee is losing their job and where they want to know why they're losing their job, it totally flies in the face of all of our good faith obligations, all of the work the legislation and the courts have done to go, this is a relationship, you have to communicate with your staff. So the courts have said if an employee asks you, you can't refuse to tell them. Our advice to clients is like, have the courage of your convictions and don't be a dick. Like, tell people why you're considering firing them and be clear about that to be safe. But technically, if you wanted to with a trial period, you could not front with that reason. But if they asked you, you would have to tell them. So you may as well tell them in the first place, is our view on that. Maker says, if a person shows signs of not being appropriate for a role during the probation period, but you're not sure, can you extend the probation period? The short answer is yes. So unlike trial periods, probation periods don't have a cap on how long they can be. Trial periods can only be up to 90 days. Probation periods can be any length that's kind of fair and appropriate. So commonly this happens where we see people coming up to a 3-month mark and the boss says, it's just kind of a bit marginal. Like they're not so bad I want to fire them, but there's just some stuff that hasn't resolved and is a bit orange flaggy to me or red flaggy to me. Can we extend? So there are two circumstances there. In their probation period clause, it will either say this probation period clause may be extended by up to 1 month, 2 months, 3 months at the employer's discretion. And if this happens, we'll communicate in writing. Or it will say this probation period may be extended and then stay silent or says we'll consult with you at the time. So depending on what version of the clause you have, you might be able to, in situation 1, say to your employee, hey, Sylvie, as you know, we've been having meetings with you around your feedback, your probation period's due to end in 3 weeks. But there's still some stuff that's unresolved for us. So we're going to extend your probation period from a total of 3 months to a total of 6 months because we want to support you to improve and get there, but we haven't seen enough improvement yet to be confident that that will happen. So we're extending, we'll confirm this in writing, we'll keep meeting with you. Let's kind of go. Or in a situation where you don't have that kind of discretion to extend, you may need to meet with me and go, hey, Sylvie, we've been meeting with you around our concerns. Your probation period is due to end in 3 weeks. We would like to propose extending your probation period to 4 months total or 6 months total, whatever it is, because of these reasons. You can seek legal advice on this. You can agree or disagree. If you don't want to extend it, we may consider ending your employment in 3 weeks under the probation period. We don't want to do that though. We want to give you another 3 months to kind of get to where we need you to be, but we have to agree to this. We don't have the ability to extend without consulting. So the short answer is yes, you can extend a probation period. Depending on what the employment agreement says, you might be able to do that without consulting, just at your discretion, or you may need to consult with the employee before you can go ahead and do that. Anonymous says, if your probation period is 3 months and you are giving feedback and telling them the consequences of their performance, can you terminate straight away or do you need to give a written warning first? Excellent question. You cannot terminate straight away. So you need to give them enough training and support to like meaningfully help them learn the job and how to be successful. You need to give them feedback if they're not meeting your expectations and support to improve. You need to be clear with them that if they don't improve, the consequence might be their employment being terminated. And if you're continuing to support them and they're continuing not to improve, then towards the end of the probation period, you can start the termination consultation. So that looks like sitting down and saying, hey, Sylvie, your probation period ends in 2 weeks. Over the course of your employment, you have received this training, supervision with this person, training course here, supervision, whatever it is. We've met with you on these 6 separate occasions to give you feedback. On the 3rd of those occasions, we told you that your job might be on the line. We haven't seen an improvement, and now we're proposing terminating under the probation period. Sylvie, go away for a couple of days. Seek advice if you want to, have a think about it, come back and give us your feedback. Once we've heard that, we'll consider it and make a response. So there is a consultation piece right at the end when you're terminating, and that's the same if it's a trial period or a probation period, but you don't have to give them a warning. You just have to give them appropriate support, meaningful feedback, support and time to improve, clear instruction or clear advice that their employment might end if they don't improve, and then you can run that consultation at the end. Anonymous asks, do you think we may put talent off by joining us with a probation period? Yeah, I think is the short answer there. Probation periods aren't uncommon and trial periods aren't uncommon. So no one's going to go, oh, goodness me, I've never heard of a probation period in my life. You guys are insane. No one's going to do that. But if you have someone who's in a highly sought after, with a highly sought after skill set, so software developers, anyone in IT, anyone with kind of senior leadership skills, they are going to have a lot more power in the labour market because they're going to have more people who want to hire them. So they will have more leverage to say, I don't want a probation period. I back me to be amazing. If you don't back me to be amazing, these 4 other companies do. And so I'm kind of not interested if there's a probation period. So it's always negotiable, but I would totally understand if someone didn't want to deal with the risk of that and chose to go elsewhere. So it depends. Like my advice would be, are you getting pushback from people around probation periods? If yes, do you want to consider not using them? Weighed against that is how useful have you found them? Like, have you been able to get rid of some really bad apples quicker and stop them? If one bad apple spoils the barrel, right? So have you been able to protect your team and your business by having them? And there'll be a trade-off there, which means you either might choose not to use probation periods or you might choose to use them. But if you're in a really, really, really tight industry and you're finding it hard to find good people, getting rid of probation periods would be one thing you could do to make it more attractive to come and work for you. Can wrong culture fit be reason enough to end someone's employment during a probation period, or does it have to be tied to performance? Thank you, Anonymous. This is a tough question to answer. The short answer is yes, the wrong culture fit can be enough. Where it becomes difficult to quantify is, what do we mean by the right culture? Like, what are the behaviors that we would expect to see from someone who's a good member of fits with the culture, versus what are the behaviors we're seeing that this person doesn't demonstrate? So as long as you can say, here are the behaviors that indicate you are not a good cultural fit. You never offer to help your teammates out when they're overloaded. You roll your eyes whenever you get feedback from a senior member of your team or from your manager. You regularly ignore instructions and have to be like persuaded to do your job. You are really thoughtless with the way that you hand over your project to the next person in the process, and we've told you about that and you haven't improved. So as long as we can name and identify what those behaviors are, we can totally say that that's not acceptable. As long, again, as we've given them support and training, we've given them that feedback, we've helped them understand what good culture looks like at ABC Limited, and we've given them the heads up that if that doesn't improve, we might end up firing them. If that's all happened and you're clearly articulating the behaviors that are problematic, yes, you can end someone's employment for being a kind of a poor culture fit during a probation period. Anonymous asks, how many warnings do you recommend before terminating within the probation period? Similar to that answer before, I don't recommend any warnings. You don't need them. They're already in a period of probation, so you don't have to like hammer it home. But you do need to give them support, feedback about what is and isn't going well, opportunity and meaningful support to improve, a heads up that their employment might end if they don't make that improvement, and then you can consult around ending at the end of the probation period. But having warnings in place, you don't need to do. That would be over-egging it. Anonymous asks, if a new employee doesn't have the capabilities they advise within the recruitment process, can you use the termination in the IA re not being truthful within the recruitment process? Yeah, great question. That's a gray area. So at one end of the scale, if you, how do I explain that? If at one end of the scale they blatantly lied and you later find out about it, so they say that they do have a full driver's license when in fact they don't, or they say they had a bachelor's degree from Auckland University and you find that they don't. So wherever there's like a deliberate lie or a lie of omission, that is a matter of serious misconduct, and that's a way quicker path to termination because they've lied, right? That's a fundamental breach of their obligations to act in good faith and to kind of work with you and be honest. So where there's a really deliberate lie or they've not been truthful, yes, that's a pretty quick exit route. More often what happens though, and I think this is getting to your question around capability, if you believe that you were getting a senior recruiter, I don't know, accountant, and they talked as though they knew what they were going to be doing. You explained the duties of the job and they went, yep, I'm really confident I can do that. You interview, whatever you did, and you believe they were going to be good enough. And they show up and you've got like an accounting grad who can basically like barely use Excel. That's harder to fire someone for being untruthful. Because as the employer, it's kind of expected that you will do your due diligence before hiring someone. So in a situation where you recruited for someone, you, to the best of your ability, maybe gave them a speed typing test. You did interviews which were structured and thoughtful. You checked references and you had them come in and like do a work sample, so write a few emails. If your recruitment process was really thorough and they still showed up being far, far below where you expected them to be, I don't know that if you, depending on the facts of the situation, I think it would still be easier to move them on for underperformance because they just won't be able to do the job ultimately, right? So that would be your fallback way to terminate them. I just don't see if you could, if it's a truthful thing. Sometimes there is just a mismatch of expectations. At the other end of that spectrum, if you like barely interviewed them, so you called them in for half an hour, had a chat, and then said bye. If you didn't do references, if you didn't ask to see a copy of their driver's license, if you didn't ask for proof of their tertiary qualification, basically if you did hardly any due diligence and just had massive gaps in your recruitment process and they showed up and they were rubbish, you have to own that as the employer. There's no way you could be able to fire them for being untruthful because what were they being untruthful about? Like they showed up to a half an hour interview and then you gave them the job. Like they didn't do anything wrong. So if they've lied and told you they have a degree when they don't, yeah, that's a serious misconduct issue. Whether you've run an amazing process or whether you've run a shit process, probably performance and not being good enough for the job is going to be your way to terminate them rather than like lying or a truthful piece. Super dependent on the facts though, so do take some advice if that's something that you're managing. Anonymous asks, if the employee isn't interested in your help to improve their performance, does this affect any good faith or make any difference to letting them go for poor performance? The short answer is no. So you can't force someone to try and improve. Your only legal duty is to give them the opportunity to. So we can lead a horse to water, but we can't make it not shit at its job, right? So as long as we're saying, hey, Sylvie, I'm offering you weekly catch-ups with me to kind of troubleshoot and talk about issues. I'll get a senior barista to show you how to make iced mocha, half-fat lattes or whatever. So all of the support is going to be here. And if I'm going, nah, fuck it, I'm amazing, I don't need the training, and then I'm still rubbish at my job, my employer hasn't done anything wrong, right? They've offered me support, they've offered me the training, they've offered me the coaching. If I'm the one who's failed to engage as an employee, I haven't taken up that opportunity to improve. So when I get fired, it's not because my employer hasn't tried to help, it's because I haven't engaged. So if your employee's like ghosting you and not really picking up these opportunities, that's fine, as long as you're being really clear that they're there, and as long as you are trying to meet them halfway and you're trying to be supportive, you'll be fine. Cool. What if Haley, kia ora Haley, says, what if performance is linked to absenteeism? Can we have that as a reason for dismissal if they're calling in sick one day a week? Not really. It's really fact dependent. So if you have someone who, so at the probably couldn't fire them end of the spectrum, is if they told you, before they signed up for the job that they had something like a chronic health condition like Crohn's or like lupus, or they were going through, I don't know, chemotherapy for a low-level cancer, and you know about that, and they say, look, I might need a bit of grace and a bit of kindness because I'm going to have days where I'm quite unwell and can't work. And if you've taken them on knowing that, and then they're kind of sick regularly, they've been perfectly truthful and you've accepted to bring them on for that reason. So I can't really see a way you could legally fire them for underperformance if that's the reason. There might be a different conversation to say, Sylvie, this is a 40-hour-a-week job and you're kind of regularly only here for like 25 or 30 hours. Can we have a conversation with you around what you might need from us to support you? And that might need to look like reduced hours. On the other hand, if someone's taking the piss, so hasn't disclosed any sickness, always calls in sick on a Friday or a Monday, like we all know someone like that, and they just, for whatever reason, can't do the job, I think you could probably work that into that unsuitability for the role conversation to say, Sylvie, we have tried to talk to you about your absences. You kind of stonewall us or don't really engage. We've told you that this is a 40-hour-a-week role, and if you can't commit to that on a weekly basis, then we might fire you under your probation period. Your absences haven't improved and you still continue to be sick kind of beyond what we think would be acceptable. We're now going to end you under the probation period. I think that could be okay, but it would need to follow like conversations to ask me if I'm okay, like asking for medical certificates because I won't have sick leave at that point. Clear expectations around communication about absences, clear expectations around how many hours a week, telling me that if that's not good enough that I might lose my job. So all of those things would have had to have happened to go, you clearly can't commit to 40 hours a week, we're going to let you go. So that was quite messy, but I think there would be a pathway, but very, very fact specific, and would depend a lot on what my responses were when you asked me why I was off so much. Linley, kia ora Linley, how you doing? Asks, if someone is returning to your business to the same job as they had when they left, can you still use a probation period? Yeah, that would be fine as long as they agree to it. I don't think it's unlikely to be successfully challenged, but what would make it safer is if you could point to significant differences, maybe not differences, but maybe different ways of doing things. So if you had someone in a call center who worked for your business when you had software A in place, and that was fine, they left your business, you then changed your call center software from software A to software B, and they wanted to come back, saying, hey, we want to put you in a probation period because we've got this whole new platform. It's different enough to when you were here that it's a slightly different way of working. We just want there to be a probation period to make sure this is going to suit everyone. That would be fine. So I think in most circumstances, you could have one. It would be safer if you could point to why you wanted to have one. But speaking from my perspective, if I left an employer on good enough terms that later I wanted to go back to them and they went, hey, Sylvie, awesome, we're stoked to have you back, come on board, hey, there's going to be a probation period, I'd be a bit surprised, like, why do you want me back if you're not sure I'm going to do a good job? So not that it's not legal to have them, but you might fairly expect some questioning or a bit of being a bit taken aback that you would put one in place when you've already worked with them and like them enough to have them back. So Maker asks, can a person be let go during a probation period for not being a good cultural fit? Yeah, same answer to the question as before. You need to demonstrate what the specifics are around what the behavior is that means they're not a good cultural fit, and you need to manage everything appropriately along with the pathway to termination. But if it's just, we kind of don't like you and you're not as cool as the rest of us, no, not that I'm saying you would do that, but you need to be able to point to specific behaviors and have been identifying them and talking about them as you go along. We've got 2 more questions from anonymous folks, and we're already at 3 p.m. So I'll answer these 2 and then we'll wrap up the session. Anonymous says, if an employee is still on their probation period, started turning up late for multiple shifts 2 months after they've started, have said that they've become emotionally unstable because of a heartbreak, if after a month they still have not improved and continue to show up late, if we've got proper catch-ups and have a disciplinary process in place, would we be able to dismiss this employee? Totally hypothetical, right, Anonymous? That's not specific at all. The short answer is whether someone is under a probation period or whether they're not, if they are regularly unable to meet the requirements of the role, which in most cases involves turning up on time, communicating if you aren't turning up, behaving professionally at work, doing what's required of you, there is a pathway to dismissal. If they're still under the probation period and you've been managing that and communicating with them and giving them a chance to improve, yes, you can probably terminate them. If they're not under a probation period, it would probably, and even if they were, it would probably be a chat to go, Sylvie, you just look like you're having a shit time right now. Like, we know that you've had a bereavement or you've broken up with your girlfriend or whatever it is. Do you just need a week off to clear your head, get yourself sorted, and then come back to work? Or, Sylvie, you've just had a really big loss or breakup. Do you need to go down to 4 days a week for a while just to kind of give yourself a bit of breathing room and then look at coming back to full-time hours? So if you like, it sounds like you don't, but if you like the employee and know that they're just going through a bit of a shit time, like life happens to all of us, right? We can't avoid that. Then it may be worth trying to find an alternate kind of arrangement where you're giving them a bit of support and a bit of space to keep them around. But if you don't want to do that, or if you've tried that and it hasn't worked, or if they're in a probation period still anyway, you will have a pathway to dismissal regardless of if they're under a probation period or not. Seek some legal advice because that's a bit nuanced. If you're a MyHR client, it's something we help our clients out with all the time. But yes, there will be a pathway to moving someone on. Cool. Anonymous asks, can an employer, this is a juicy one to end on, so thank you to whoever submitted this. Can an employer terminate the probationary employee due to the company's financial issues? For example, if a company needs to decrease the number of employees because of the pandemic or other challenges. No is the answer. So if you're under a trial period, so you've got 19 employees or fewer and a trial period is valid, the law actually says you can use the trial period to exit someone even if it isn't for performance or behavioural concerns. So the test case for this was almost exactly that situation. So the employer had some financial challenges, needed to reduce headcount, had an employee on a trial period, let them go under the trial period clause because they were bleeding money and needed to reduce costs. And the court said that was fine. Like the courts didn't say that was inappropriate. However, a probation period is specifically for the purposes of assessing suitability and fit for a role. If you have an employee on a probation period, they are still an employee, right? They still have access to all of the same processes and rights and privileges as all other employees, which includes if there's a restructure or job cuts being considered, to be taken through a consultation process, explained why it is you're doing what you're doing, and to have the right of reply. So if you had a probation period in place and you ditch them, even if you followed an appropriate process, but you ditch them for not performance or behavioural reasons, they would bring a PG against you for unjustified disadvantage because they weren't given a chance for right of reply to the restructure, and they would win that claim. So like all of the rest of your staff, just take them through the appropriate restructuring process. It would be my advice. Trial periods are kind of a big fat asterisk here because we know that we can use them for reasons other than performance and behaviour. Probation period employees, I wouldn't advise it. Just treat them like the rest of your staff and give them the right of the reply like everyone else does. Holy, so be careful what you wish for. I asked for questions and you lot certainly delivered. I hope the session has been helpful or at least informative. Thank you so much for joining us this afternoon for this conversation. The session has been recorded and will be made available probably after Easter at this point because it'll take a minute to get it up. But if you do have any questions, get in touch. We're at at myhr.works. Our number is 0800 69 4769. Again, help@myhr.works. Recording will be out next week. And I so appreciate your attendance today and hope that you got something out of it.